15 days of the issuance. So we will pick that up next.
Yes, Your Honor. If I could, just from a historical standpoint, give some information. Your Honor, I represent Mrs. Phelps, who is now Miss Miles. Parties have two minor children. They were divorced back in January of 2024 by agreement. The parenting plan that was adopted at that point in time designated the mother as primary residential parent, and they had a basic equally shared residential schedule, although the mother is 183 days, the father is 182 days. But they did exercise a week-to-week visitation schedule. But in the other section on the parenting plan that's set forth on page 3 of their parenting plan, there's a specific prohibition that the father shall not consume alcohol to excess during his parenting time.
Right here, we get the first major clue about what's driving this hearing. The mother claims the father violated a key term of their parenting plan, the rule against excessive alcohol use during parenting time. This is not a casual guideline. It's a court-ordered boundary meant to protect the kids. The attorney hints at past issues, AA meetings, and a relapse. What's striking is that everything seemed manageable until one serious turning point: the alleged DUI with the child in the car. This is where cases shift from parental disagreement to potential endangerment. What do you think? Should violating a no excessive alcohol clause automatically trigger an emergency review?
I believe the testimony will be that there was an issue with alcohol during the course of the marriage, and that the father had begun after the marriage going to AA and abstaining from consuming intoxicating beverages, and was attending AA. We have some documentation to that effect. So the parties have rocked along for a period of time until June of this year. There's been some indication, my client would say, that alcohol has started to become a problem again. And in June of this year, the testimony is going to show that Mr. Phelps, while he had the party's eldest child, their son, in his possession, that he was arrested. He was pulled over in Robertson County, operating a motor vehicle. He failed the field sobriety test. There was a blood test administered, and he was charged with driving under the influence and endangerment of a child. My client, he never disclosed this information to my client. My client, the testimony will go, found out, as many people do, through a mobile patrol and social media application, that she found this out. She reached out, testimony will be, to try to discuss it with him to see what the situation, and he's refused to discuss it. She came in saying that it had become a problem, came in October, retained me. We typed up a petition to modify the parenting plan and asked that a restraining order be filed. We got that ready about the time when there was some judicial conference things going on. We forwarded it over here, and Judge Turnbow signed the restraining order on the 24th, Friday, the 24th of October. And so at that point in time, the court forwarded me a copy via email. And I notified my client, but it was going to be Mr. Phelps's week to have the children. And so the kids went on because, again, he had no notice and he was not served with the restraining order. And my client did not want to be put in the position of having to deal with that. So he had them the week. We came before the court last week in front of Judge Turnbow. Mr. Phelps had not been served. So he moved it to Your Honor's date today. As I understand, even though it's not back in the record yet, that Mr. Phelps was served on Saturday. And so what we're here is to determine whether the restraining order should be extended. It's his time tomorrow to get the children. So either asking that the restraining order be extended due to the fact that he put the party's eldest child in significant threat of harm by driving under the influence, or in the alternative, to put down provisions, Your Honor, that precludes him from consuming alcohol in any way during his residential time, or subjecting the children to any individual consuming alcohol so that this is protected. I haven't, I'm going to be asking him when his court date is, when he takes the witness stand, but that was the basis of us seeking this restraining order, Your Honor.
All right.
Your Honor, I'll attempt in no way to educate the court, as the court is well educated beyond my knowledge. But we are aware that in order to receive one of these ex parte restraining orders, there's a word that is involved, and it is in an emergency. These situations occur in an emergency, Your Honor. We would say that the child needs to be kept from the father for an emergency's purpose. Your Honor, in reading the petition, I would like to point out that very conveniently, disingenuously, however we would like to put it, there's no dates that are listed for reading the petition as to when these facts occurred. And so, Your Honor, I would say, yes, there is an attachment to this lengthy document that does state that the arrest occurred on June 22nd. I believe that you will come to find out that mother had knowledge of this as early as June 25th, Your Honor. June 25th. There's no, Your Honor, you will hear of nothing else other than this arrest. You will hear no facts where my client has put this child in, or these children rather, at harm in any way. Your Honor, you will hear that on July 1st, mom okayed parenting time. You will be able to see text messages where she stated that was fine. Your Honor, CPS has been involved. This has been going on for 18 weeks since July 1st, and all of the parenting time has occurred as it should in accordance with the parenting plan. The issue here, Your Honor, is solely one of the emergency. There's a petition to modify the parenting plan. We call them permanent parenting plans. They're anything but permanent. But nonetheless, there's an avenue by which that the mother can now move. She does have a petition to modify the parenting plan. But Your Honor, I would state that you could see now, without having to hear from anyone, this is not an emergency. She's allowed for 9 weeks. There's been 18 weeks. They have week on, week off parenting time. She's allowed for 9 weeks of parenting to occur, Your Honor. She's not afraid of irreparable harm. If she was afraid of irreparable harm, she would have been afraid of it on June 25th. Here we stand now. It's October. Mom, I know we heard that there was judicial conference, Your Honor, and some things of that nature. I've drove all over the state to get these emergencies signed. I've gotten in my car and drove and found judges in their living rooms, Your Honor. So signed on October 1st, not filed until October 21st. Event occurred on June 22nd, and mother had knowledge of it on June 25th. Your Honor, there's a petition to modify down, but I would state that I don't know that this ex parte should have been granted. And certainly I'm arguing that there's no fear of irreparable harm. If it was, it would have already existed.
All right, well, we'll reserve that following the hearing, and I'll make a ruling. So, Ms. Roberts, you may put on your proof.
Your Honor, I would call Mr. Brian Phelps.
Well, let's come around, please.
You go climb up with the mouse. Before you sit down, raise your right hand.
Thank you. Have a seat.
Yes.
Your name is Brian Phelps, is that correct?
Yes, ma'am.
And Mr. Phelps, where are you currently residing?
1070 James Circle, Ashland City, Tennessee.
And who resides there with you?
My girlfriend, Jennifer Stamps.
Jennifer what?
Stamps,
And how long have you lived there?
October 1st.
October?
October 1st.
Prior to that, you lived with your parents?
Yes, ma'am.
And that's where you exercised your residential time, is that correct?
Yes, ma'am.
You understand that you and your ex were divorced back in January of 2024, correct?
Yes, ma'am. Danny.
Y'all entered an agreement,
Ma'am.
and part of that agreement was you would have a week-to-week schedule with your children, correct?
Yes, ma'am.
And I think you exchange on Fridays. You were also supposed to split and pay half of uncovered medical expenses, schools expenses, extracurricular activities, things such as that. Is that correct?
Yes, ma'am.
And you understand in that provision, in that order that you set forth in your final decree, that you were not to drink to excess with the children. Is that correct?
Yes, ma'am.
And you recall that as a provision of your parenting plan that you signed.
Yes, ma'am.
Did you have an attorney at the time of the introduction of your divorce, or were you pro se? Did you represent yourself, or did you have an attorney?
I was balanced.
But you had an opportunity to read that and understand you weren't supposed to do that. Is that correct?
Yes, ma'am.
Now, it's not disputed that at the point in time, around the time of the divorce, that part of the problem in your marriage was related to alcohol consumption. Is that correct?
Okay.
We could maybe get some direction as to the relevance of this hearing. We're here for the ex parte purposes of what this particular order is. I would like to keep it to the DUI and the timeliness by which it was filed therein.
It's purely foundational, leading to the fact of that he had an alcohol problem and knew better not to drive with the kids. That's,
And
again,
that's,
simply foundation.
that's an issue by which there's hearing that can be filed by. This is an emergency process, extraordinary. I'd like to keep it to that.
Overall, I think it goes to the issue of why the petitioner is seeking a restraining order and the circumstances of it. Again, the order as it presently stands does not prohibit the use of alcohol. It just prohibits the excessive use of alcohol. So I'm allowing it not to consider that for any purpose other than to lay a foundation.
So again, there was some issues in y'all's marriage about alcohol use, correct? And in 2024, you actually started going to Alcoholics Anonymous. And you notified your now ex-wife that you were going, and you were working on issues as related to the overconsumption of alcohol, correct? And so that was the reason why that provision was put in there. Is that right?
Yes, ma'am.
There was a basis for it.
Yes.
Okay. And you had made promises and statements that you wouldn't consume to excess or be under the influence when you were with your children,
Yes.
correct? And for the most part, you complied with that, didn't you?
Yes, ma'am.
Here recently, you've started drinking a lot more, haven't you?
No, ma'am. I still drink, but I don't, them kids are good.
Okay.
I mean,
Well, tell me what transpired, if you would, on June 22nd of 2025. You were in Robertson County.
Mm.
You were operating a motor vehicle, is that correct?
Yes, ma'am.
What kind of motor vehicle were you operating?
2008 D71, my truck.
A Chevrolet Silverado pickup truck?
Yes, ma'am.
Brand new?
No, ma'am. 2008.
2008, okay. A 2008 Chevrolet Silverado owned by you,
Yes, ma'am.
and your son was with you.
Yes,
And
ma'am.
what's your son's name?
Bentley,
And how old is Mr. Bentley?
13.
13 years of age. And you and he like to go and do tractor pulling and things like that, don't you?
Yes, ma'am.
And where were you going? What, was it your regular time with Bentley on this?
Yes, ma'am.
Okay. And where, you have a daughter,
Yes, ma'am.
and what is her name?
Shayla,
And how old is Miss Shay?
she's 10.
She's 10.
Yes, ma'am.
And so this was, do you remember the day of the week that you were pulled over?
It was on a Sunday.
A Sunday.
Yes, ma'am.
And do you know what time?
5:30, somewhere in there.
In the afternoon, not in the morning.
Yes, ma'am.
And so where was your daughter?
She was with my girlfriend, Jim.
Okay. And where had you been that day?
I had been with my son fishing. We went to a creek with a friend.
Okay. And did you post some pictures of that event on your social media page?
I think I did.
Okay.
Yes, ma'am.
And you were drinking? And this may not have been the time. If I could pass to finish on
What is it you're passing?
photographs
You may.
you get those,
Yes, ma'am.
you get photographs,
Yes, ma'am.
you tell me what those photographs would be.
Yes, ma'am. Me having a beer, me drinking. Yes, ma'am. Yes, ma'am. Yes, ma'am.
Next, we'll mark it as Exhibit 1.
What time of the day were those photographs taken?
11, 12.
11 or 12
Yes,
earlier in
it
the
was midday early.
midday?
Yes.
And who all was with you?
It was just me and Bentley.
Okay, and then
in the truck.
they were just, where were y'all?
Off George Boyd Road at a friend's house. Caleb Cantrell was.
Okay. And so y'all were out there with some friends And you were drinking.
Really? Yes, ma'am.
And I think it shows a beer maybe in your hand.
Yes,
Is that
ma'am.
correct? And then did you continue to drink throughout that day?
Yeah, not,
As we move deeper into the testimony, notice how the questions tighten around the father's timeline, his choices, and most importantly, his judgment. The attorney strategically walks him into admitting he consumed 8 beers over the course of the day, drove with his 13-year-old son in the front seat, and was subsequently arrested. From a legal perspective, the emphasis isn't just on drinking, it's on decision-making. Drinking while not hiding it, posting photos, and then getting behind the wheel creates a narrative of recklessness. And for judges, consistency of behavior weighs heavily. If the kids witness unsafe conduct, that becomes a serious custody factor. So here's a question for you. Should the court focus more on the DUI itself, or the pattern of minimizing behavior before and after the arrest?
when I got in the vehicle, I had.
Let me interrupt you for a moment. Is your DUI case still pending?
Yes, sir. I've not even been to court for that yet. That's November 17th.
I feel it incumbent upon me to advise you of this fact. You, as a criminal defendant, have the right to refuse to answer any question that you think that your answer might tend to incriminate you and give evidence against you that can be used against you in a prosecution for driving under the influence. I don't know anything about your DUI case other than the fact that it allegedly occurred. I'm not telling you anything other than the law provides you. You are presumed to be innocent of the charge, and as a result, you don't have to answer any question if you think your answer might tend to incriminate you. But to do so, you have to invoke your right under the Fifth Amendment of the Constitution to avoid answering it. I'm sure your lawyer's gone over that with you, but I feel like it's incumbent upon me to put it on the record. So, Ms. Roberts, you may continue.
And just on the note that the judge was explaining to you about your right to not incriminate yourself, you understand that this is a civil proceeding. You understand there's a criminal proceeding. Criminal proceedings end up putting you in jail.
Yes,
A
ma'am.
civil proceeding, unless you're in contempt of court, is for the judge to put down orders, not necessarily jail somebody. You understand that?
Yes.
But if you invoke your Fifth Amendment privilege in a civil proceeding, then the court can take can assume that the statement that you refuse to answer would incriminate you. You understand what I'm saying?
Yes,
So if I ask you, were you drunk? And you say, I'm going to invoke my Fifth Amendment privilege, the judge can assume you were drunk. Okay, we understand that?
Yes, ma'am.
Okay, good deal. All right, so you were there, you continue to drink throughout the day.
Yes. Not the whole day, but I did after the pictures. Yes, ma'am.
And do you know how many you drank that day?
It was 8 beers altogether.
8 beers. What time did y'all get to the creek?
It was noonish. It was around lunchtime, between 11 and 12.
11 and 12. And and that was when you first started drinking?
Yes, ma'am.
And so from then until what time did you leave?
It was 5:30.
And and you got into a car with your child.
Yes, ma'am.
And is it a king cab where you have 2 seats, or is it just
Extended cab.
okay. So where was Bentley seated?
Beside me. Pastor.
He was in the front seat with you.
Yes, ma'am.
Because he is old enough and he doesn't have to have child restraint or anything
Yes,
like that.
ma'am.
So he was in the front seat with you.
Yes, ma'am.
And he witnessed you drinking throughout the day.
Yes, ma'am.
I mean, it wasn't anything you were hiding.
No, ma'am.
Okay. And you got in the car, turned on the car, and operated the vehicle, correct?
Yes, ma'am.
And you drove that vehicle over public roads.
Yes.
You pulled out did you park at a friend's house?
No, we took it back to the creek where we all was.
Okay. So whoever owned that property back there, you went to the creek, you got in the car, you drove out of where it was and got onto another road
Yes, ma'am.
that is maintained by the state and county and that other people traverse and drive on, correct?
Yes, ma'am.
And you operated that vehicle with your child in the car with you.
Yes, ma'am.
And shortly after you got on the road, a police officer pulled you over.
Yes, ma'am.
And again, he administered when you got there, when he pulled you over, did you immediately pull over
Yes, ma'am.
and get out of the car? Or did you wait for the officer to come up and get to your,
Waited until the officer came up together.
okay. And so he came up to your window and asked you if you had been intoxicated, if you had been drinking.
Yes, ma'am.
And what was your response?
Yes, sir.
And again, that's on a body camera.
Yes, ma'am.
And he asked you to step out of the vehicle. And at that point in time, what transpired?
Went around back and he He was an off-duty cop. He was waiting on another officer to get there. He went around back. He performed his test on me. And
Okay.
it took me,
So I asked this question not offered for the truth, but did he tell you why he pulled you over?
he said my truck had come over the lane.
It wasn't a busted tail light or your license wasn't
Not speeding.
done. It was the way you were operating the vehicle is what he alleged.
Yes, ma'am.
And he pulled you over. You got out, went to the back of the car in front of his, and waited for an officer to get, a on-duty officer to get there, correct?
Yes, ma'am.
Officer arrived
Yes, ma'am.
and you were asked to do certain field sobriety tests.
Yes, ma'am.
And they indicated to you that you performed poorly on those,
Yes, ma'am.
correct?
Yes, ma'am.
And as a result of that, they placed you under arrest for driving under the influence. And they arrested you and charged you with child endangerment because your minor child was in the vehicle. Is that correct?
Yes, ma'am.
And instead of calling the mother of the child, you called your girlfriend to come pick him up.
Yes, ma'am.
And you never contacted and told your ex-wife that you had been arrested, did you?
Actually, my son called my girlfriend, not their mother.
Okay. So your 13-year-old, you did say 13, right?
Yeah.
13-year-old son witnessed his father being arrested for drinking
Yes, ma'am.
and driving.
Yes, ma'am.
And then he had to call to get somebody to pick him up.
He called my girlfriend Jennifer.
Okay. But you didn't call his mother.
No, ma'am.
And to this day, when she found out about it, she texted you and said, "Hey, what happened?" And you've refused to discuss it with her, haven't you?
No, ma'am. We have text messages to document that was otherwise. She
Okay.
wanted to meet up at my mom's.
Mm-hmm.
It was brought up that she was going to be at my mom's. I went to my mom's. She didn't show up. And so in the text, like I said, I printed them off. We got
Okay. Was this after you got released? How long were you held?
14 hours.
14
They
hours.
went through 2 shift changes. I was supposed to have been in there 4 hours and out.
Mhm.
I was in there 14.
Did they administer a blood test to you?
Yes,
Did they take you to a hospital?
Yep.
And have you got the results of those tests?
yes, ma'am.
And what were those results?
0.19.
0.19.
Yes.
You understand what the legal limit is?
0.08.
Okay, so you were over double the limit, right?
Yes, ma'am.
Okay. And it's true, is it not, that after that transpired, she reached out to you, y'all, maybe again, matter of perspective. Have you ever sat down and explained to her what happened?
No, ma'am.
Has she asked you?
No, ma'am.
But in fact, the truth of the matter is, sir, is even after the arrest and your child witnessed his father, who he's very close to and learns by example,
Yes, ma'am.
you've continued to drink.
Not and drive for my kids.
And I didn't ask if you were
Yes,
driving.
yes,
You have, after you blew 0.19, or excuse me, not blew, your blood alcohol indicated you were 0.19.
yes, ma'am.
You have continued to consume alcohol, correct?
Yes, ma'am.
Even though you've had a prior history and you haven't been to a treatment program, you just went to AA, is that right?
Correct.
And you drank when your children have been with you.
Yes, when I have been. Yes, ma'am.
Although you may not have driven after drinking a lot, but you've driven after you drank. You've had a beer and driven with your kids, haven't you?
No, ma'am.
It's your testimony here today in front of the court under penalty of perjury that after June, when you were arrested, specifically June, sorry, let me flip back over. June 22nd of 2025, it is your testimony here under oath that you have not consumed an alcoholic beverage and driven with your children after consuming, not whether you're intoxicated, just whether you drank a beer or a mixed drink. Because again, some people like to post things on social media, so I'm not trying to pull any punches with you.
Right.
Okay? And you've been over here to the Mexican restaurant, I think it is, and had you a beer sitting in front of you with your kids, and you drove there with the kids, right?
I don't know if I drove or not. I have had an alcoholic beverage and been places
And driven with your children, haven't you?
No, ma'am, not driven. No, ma'am. I have been places with them. Jennifer drives, I don't drive.
But she was drinking too.
I had gotten through.
Has she been drinking? Isn't there a
She has-
beer in front of her
she has-
too?
She has consumed alcohol before.
Driven with your children?
No, ma'am.
You're sure?
Just saying.
Yeah. Think it was appropriate, driving and drinking, how many did you say? 8 or 9? I don't want to put words in your mouth.
No, ma'am, it was.
But you continued the behavior of drinking with your children present.
Yes, ma'am. But it's not.
What kind of
appropriate.
example do you think that sets for your kids?
It's not a good one.
Then why are you doing it?
It's something that's being worked on.
How?
I have consuming alcohol.
You're what?
I haven't been consuming alcohol. It's
Well-
something that I've been working on. 14 hours in jail is a long time to sit there and think about it. And
So
going
you're,
on from that, I met Jennifer, and she has made a big impact on that too. My kids are my world. A lot more important than alcohol.
well, I hope so, but you drank this past weekend, didn't you?
Yes, ma'am.
Well, you said you quit drinking alcohol, so when,
No, I haven't, but I've slowed way down.
oh, you just slowed down. All right, thank you, sir.
We'll see you may question the witness.
No, you didn't. No, he's gonna question you now.
I'm sorry.
This portion of the hearing is especially important because the defense attorney tries to dismantle the idea of emergency. He highlights that the mother knew about the DUI within 3 days, allowed normal parenting time for nearly 18 weeks afterward, and only filed in October. Legally, this is a strong attack. Courts define emergency as requiring immediate action to prevent harm. But the mother's argument seems to hinge on the severity of the incident combined with later information, like the blood test revealing a .19 BAC, more than twice the legal limit. That's a significant detail. So the question becomes, does delayed action weaken the legitimacy of the emergency? Or does the seriousness of the DUI override the timing? Where do you stand?
Mr. Phelps,
Yes, sir.
you know what an emergency is?
Yes, sir.
What's an emergency to you?
When my kids are drowning, we automatically jump in and save them. It's something that happens and occurs, and then immediate action is taken.
Does it occur as soon as you have knowledge that they're drowning?
Yes, sir, right then.
Were you pulled over on June 22nd of 2025?
Yes, sir.
Were you then knowledgeable that your ex-wife was knowledgeable of that event within 3 days?
Yes, sir.
You may.
Mr. Phelps, will you please tell the court what you're looking at there?
I'm looking at where Miss Chastity sent
And who's Miss Chastity for the court?
a.
Tell the court who Miss Chastity is, please.
Miss
who-
Chastity is my ex-wife,
Thank you.
the mother of our children.
Thank you.
This is where she has sent out a group message to me, my mother and her mother of my mugshot, my arrest records.
Is there a date on those text messages?
Yes, sir.
What's that date?
June 25th.
And that's 3 days subsequent to your being pulled over, is that correct?
Yes, sir.
And that's, mother has knowledge of what occurred, correct?
Yes, sir.
Your Honor, if I can make that the next numbered exhibit.
You may.
What are you looking at there, sir?
Yes, sir. Text messages between me and her mother.
Okay, what's the dates of these messages? Let me ask you a
This is 3
question.
days.
Do all of these messages pertain to the events that occurred on the 22nd of June?
Yes, sir.
Is it okay to believe that these messages took place after the 22nd of June?
It will stipulate that they were the day, 2 days after she sent the text
Right.
message, I believe.
Stipulation is that they occurred after the day of his arrest.
Are you in a conversation with the mother there?
Yes, sir.
On the last page, if you will, please, is there a July 1st text message?
Yes, sir.
All right, if you'll read to the court your message to the mother and her response.
Just double checking. I will be picking up the kids at 8 a.m. Saturday morning, according to our plan. I sent that
That was a message from you to the mother?
from me to the mother. The
Mother's
mother put,
response was?
The kids would like for you to pick them up at 10 a.m. on Saturday instead of 8 a.m. if you're good with it.
Did she mention anything about immediate and irreparable harm?
No, sir.
Did she mention anything about damage that was going to occur to the kids if you were to have them in your possession?
No, sir.
And so the court is well aware, she knew of everything that occurred with you on the 22nd of June, correct?
Yes, sir.
Your Honor, if I can make that the next numbered exhibit.
We'll mark the exhibit 3.
Ms. Phelps, how many times you've been arrested for alcohol consumption?
One.
Okay. So you don't have a prior history of anything, do you?
No, sir.
All right. Are you aware of the legal drinking age in the state of Tennessee? Are you currently a licensed member of the state of Tennessee capable of going and purchasing a beverage?
Yes, sir.
Has CPS come to your house regarding this issue?
Yes, sir.
Okay, and how did that go?
It went great.
When you say it went great,
They had their own bedrooms. They talked. They took pictures. They talked to me.
does the mother of the children have knowledge of CPS coming out?
Yes, sir.
Okay. Have you missed any of your parenting time since June 22nd?
No, sir.
You've not missed any of it.
No, sir.
Okay. And mother is allowing all of this to occur, correct?
Yes, sir.
Tell me when you told the mother that you were going to move in with your girlfriend,
It was right before October 1st.
and tell me what October 1st, what that was.
That was the day we moved in.
Okay. I'm gonna pass you another document if I can.
Mhm. It just the,
What are you looking at there, Mr. Phelps?
These are the papers, the ex parte temporary restraining order attached and new advised.
Is that the service packet that you received this past Saturday?
Yes, sir.
I folded a page on there. If you will go to the folded page, please. You'll see a signature by the mother of your children, where she signed a document under oath stating that she feared that your children would be under immediate and irreparable harm if you weren't kept from them on October 1st. She signed that. Do you see that signature?
Yes, sir.
Signed under oath on October 1st?
Yes, sir.
And counsel has already stated, but you have had your children since October 1st, correct?
this can answer.
Yes, sir.
And
On the front of that document, sir, what is there'll be a stamp for the day that it was filed.
Judge will stipulate that the document speaks for itself. It was filed with the court.
all right. It's a stipulation that the document does speak for itself.
Your Honor, if I can, actually, I'd like to make that exhibit, Your Honor. That's our only copy. I'm gonna need to have a copy of it.
This is your only copy?
Yes, Your Honor.
Well, this is a part of the court record already. Is it really necessary to make it? an
No, sir.
exhibit?
No, sir.
hand it back to you, then I've reviewed the documents in the files.
And again, I don't
Yeah.
have a problem stipulating that the court can take judicial notice of what's in the court file.
You're residing where now?
1070 James Circle.
In Ashland City?
Yes,
Have the children been to that home?
yes.
They have rooms in that home?
They got each other on.
Okay. Enjoy being with you.
Yes, sir.
Objection, assuming facts not in evidence.
That's all the questions I have, Your Honor.
Just a few follow-ups, Your Honor. Mr. Phelps, you just testified that Mrs. aware of everything that went on when she sent you those text messages that were introduced as Exhibit 2, correct?
Yes, ma'am.
She didn't know, as well as you didn't know, that you had blown double the limit, correct?
At that time, yes, ma'am.
Well, then why did you say she knew everything that went on? She didn't know you were 0.19 to the point of intoxication when you were driving with her child until when? When did she find that out? Do you know?
No, ma'am, I don't.
When did you find it out?
I don't know the exact date. I do know I don't know the exact date, but my district attorney that I have them emailed me a copy.
When?
What the date was?
Late September?
It was September. I'm not sure.
Okay. Again, you went and were arrested. They drew your blood.
Yes, ma'am.
And is anybody representing you on that crime?
Yes, ma'am.
Who is that?
Jeff Walker.
Okay. Mr. Walker over in Springfield, again, don't tell me what he talked about, but you understood, did you know, that they had to send that off to the lab to get tested?
Yes, ma'am.
And then they get the information back.
Yes, ma'am.
And then that becomes part of the public record when they get it back.
Yes, ma'am.
And so you didn't know how, again, I use this not as in an offensive matter. You didn't know how drunk you were until the blood test showed it.
Yes, ma'am.
Okay? And nobody did until the blood test showed it.
Yes, ma'am.
And again, do you think there's a difference between being maybe 0.08 just over the limit as being double?
No, ma'am.
You don't? Drunk is drunk.
Drunk is drunk.
Okay. And you were drunk.
Yes, ma'am.
Okay. And again, you had previously gone to AA after your divorce. You had started attending AA meetings, correct?
Yes, ma'am.
And then you quit
Yes, ma'am.
and you drank to the point of intoxication with your child
Yes, ma'am.
and you didn't stop. And again, that didn't make you quit drinking, did it?
Any other questions? Let me ask you this, what's the most important thing in your life?
My two kids.
Pardon?
My two kids.
Are they more important than alcohol is?
No, sir.
They're not?
No, sir. My kids are, oh, yes, my kids are more important. I'm sorry.
I didn't think it was.
My
the-
kids. are more
The answer
important
you wanted to
me.
get.
And
Well, you understand why I'm asking it, right? Because you're gonna have to make a choice from this point forward as to whether or not you want to drink or whether or not you want to have your children in your life.
Yes, sir.
Now, I can tell you from my own personal and family experience that they can happen. My father was a World War II vet and he was a heavy drinker on the weekends. And it was some of the most miserable experiences of my life growing up and having him drunk.
This is a powerful moment. The judge steps in not just as a legal authority, but as someone with personal experience. His remarks highlight a core principle in family court. Parenting isn't only about custody schedules. It's about modeling behavior that shapes the child's understanding of safety and responsibility. When he says, "You've testified enough under oath to be convicted," that underscores how seriously he views DUI with a child in the car. He frames the issue bluntly. The father must choose between alcohol and his children. From the court's perspective, this isn't punishment, it's protection. And his solution reflects a common judicial approach. Before removing the children, first remove the risk factor. What do you think? Is the judge striking the right balance here?
Yes,
I
sir.
didn't enjoy it at all. And all the bad memories I had of my childhood were related to him drinking and tearing stuff up and being a drunk. And he quit one day. And he just completely quit cold. He didn't go to AA or anything else, but he quit. He was a man of strong convictions when he did decide to do something. Now, if you have problems in quitting drinking, then, you may want to think about getting some help, because I can tell you, and this is quoting one of our former judges, you got an alcohol problem if alcohol is causing problems in your life, and you have an alcohol problem. Whether you admit it or not is a different matter. But you've just testified under oath enough to get you convicted of driving under the influence. You may not be planning to contest it anyway. But after I gave you my little talk, you still testified under oath about everything that's necessary for the state to convict you of driving under the influence. And so get ready, because that's what's going to happen. And unless there's some basis that I'm unaware of. In any event, what I want you to understand is I want you to see your children.
Yes.
And I think as a father that, obviously you want to do that.
More than
But
me.
you're also setting an example, and I've said this to another parent today. You're setting an example for that 13-year-old son. And would you want your 13-year-old son driving a car when he gets to be 16 after he's drank 8 beers during the day and registered a .19?
No, Your Honor. Because
anyone who's a .19 is not just a danger to yourself, you're a danger to others and to the child that's in your car.
Yes.
Now, all right, thank you. Step down.
Yes. Thank you.
Your Honor, that's our proof.
Does Mr. Phelps says, do you have anything else that you want to offer? Well, I don't need any argument in the case. This is the case that was brought on the hearing on an emergency restraining order. I don't find that to be an emergency basis for a suspension of his visitation, but I am ordering I'm going to modify this, and I want you to see your children, but I don't want you drinking when the children are there. And so you have a choice to make. And they're old enough that they can be brought in and they can testify, and hopefully they never have to. But let's just put it down that when he has the children, there will be no alcohol consumed. As we used to say, no alcohol in you or on you. So you don't have alcohol around the house when the kids are there. Just put it out somewhere else. Exercise your visitation. Try to let your children know that you made a mistake and that you're correcting that mistake. I would strongly urge you before the final hearing in this case to enroll in some sort of therapy that's going to help you with your drinking problem, because I think it seems to, from what the proof I've heard, that you need some help, and that's understandable. So there's no shame in that. It's just a question of getting some help for what you need. So let's, and when I say that there's no alcohol, I don't want your girlfriend, if you're living with her, I don't want her drinking around the kids as well. Let's just eliminate alcohol from their life while they're with you, and make a positive experience for them. But that's the only change I'll make in this case. So.
Yes, Your Honor. So just so I understand that residential schedule will remain the same, but the father is precluded, restrained, enjoined, and prohibited from consuming, possessing, alcohol either immediately before or during any residential time. The house, there'll be no alcohol in the home where he's residing.
And there it is, the final ruling. The judge determines this wasn't an emergency requiring immediate suspension of parenting time, but the father's conduct was serious enough to mandate a strict no alcohol policy anytime the children are present. No drinking by him, no drinking in the home, not even by other adults around the children. This ruling reinforces a key message in family court. Judges aim to protect children while preserving parent-child relationships whenever possible. The father now faces a clear choice: pursue treatment, rebuild trust, and demonstrate consistent responsible behavior, or risk further restrictions at the final hearing. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
And anyone who's living in the home will not drink while the children are there. Is that correct?
That is correct.
Thank you, Your Honor.
All right. Ms. Roberts will draw the order.
I'll draft the order.
Good luck to you, Mr. Phillips.